Welcome to Immigration Review, your weekly source for immigration case law updates and insights. I'm your host, Kevin A. Gregg, back again to review the week's precedential immigration cases, rummaging through the decisions so you don't have to. This podcast is sponsored by Kurzban, Tetzelli & Pratt, also known as KKTP, a law firm where I'm also a partner. Whether you are facing an immigration obstacle, a serious injury, or a legal issue in your business, KKTP will aggressively protect your best interests. This podcast is also sponsored by DocketWise, an all-in-one immigration forms and case management solution trusted by thousands of immigration lawyers across the U.S. I really like DocketWise. It makes immigration applications easy by allowing the clients to provide information through simple online questionnaires that are shareable by text or email and available in multiple languages. Not only that, DocketWise provides a comprehensive group of case management features, including invoicing and calendaring, secure messaging, task management, and a lot more. You can learn all about DocketWise and receive a 10% discount on your subscription by heading to docketwise.com/immigration-review, so they know we sent you. And as always, this show does not constitute legal advice and has no bias other than to keep you up to date and to enable you, my dear colleagues, to excel in court. So, without further ado, let's start the review. Hello. This week, the Biden administration announced its new parole-in-place requirements. Rejoice, qualified peoples, and vote like your clients' lives depend on it in November, U.S. citizen immigration attorneys. Also, in the interest of completeness, the Ninth Circuit amended its heady jurisdictional decision Tapia Coria v. Garland from episode 204. Still bad for non-citizens, but go give it a re-listen. I don't want to overly lengthen this, yet again, massive week of cases, but I always want to give the podcast's precious patrons some love. If you are a patron, and I know all of you, and you have an interesting case that you'd like me to discuss just a bit at the top of an episode, won't you please email me? I'm right here, ready to read. And you're ready to listen to these magnificent 7. Our first case is Bent v. Garland, published by the Ninth Circuit on August 15th, 2024. Quote, "This is a rare case," end quote, begins the Ninth Circuit, because both Mr. Bent and Oil want a remand. But on what terms? A split Ninth Circuit provided them. This case is about vacated criminal convictions under California Penal Code Section 1473.7A1. Mr. Bent is from Jamaica and has been a lawful permanent resident since 1980. He did not naturalize and in 2006 pled no contest to 2 felony charges in California State Court. The judge didn't mention that there might be immigration consequences, and Mr. Bent said he understood the consequences of his plea. He received 13 years imprisonment, and immediately upon his release, DHS initiated removal proceedings. He was ordered removed because at least one of his convictions matches the definition of an aggravated felony. Convention Against Torture Protection was denied after some back and forth with the agency, and the merits petition for review is actually pending separately before the Ninth Circuit. This is not that. Perhaps pro bono counsel came in shortly after that merits petition for review was filed, because right after that, Mr. Bent moved to vacate his 2006 conviction that was the basis for his losing his LPR status in the first place. The criminal court set aside that conviction under California Penal Code Section 1473.7A1. Given the Fifth Amendment violation that had occurred when Mr. Bent was unable to meaningfully understand and defend against the immigration consequences of his criminal plea. That made his plea constitutionally involuntary, said the criminal court. That conviction is attempted murder, by the way. But also, he already served his time. Call it even? No. The BIA refused to grant Mr. Bent's inevitable motion to reopen. That motion was untimely after all, and the BIA didn't believe that Mr. Bent had acted diligently enough since 2006 to try to get his conviction vacated such that equitable tolling of the filing deadline could apply. Nor did the BIA think that a Section 1473.7A1 vacature actually has immigration effect anyway, at least here, believing it a, quote, rehabilitative, end quote, vacature that was given due to the immigration hardships attendant to the criminal conviction. But that isn't what happened here, of course. This was a constitutional infirmity in the criminal conviction, which I'm sure is why Oil wants a remand. But that is what the BIA said in denying the motion to reopen. The BIA flat out ignored the reasons the criminal court judge gave for vacating the conviction, that is, constitutionally significant ones that must be recognized in immigration court, and instead relied on the plea colloquy, which it believed contradicted what the judge literally said in his order, and so was more important for immigration purposes. A split Ninth Circuit remanded. And yes, quote, the government concedes that the BIA erred in interpreting Section 1473.7A1, end quote. Gonna get to that more in a sec, but due diligence is also a problem, right? No matter what happened, the motion to reopen was untimely, more than 90 days post-removal order. Well, the Ninth Circuit believed this important to quote and put in its decision, so I think it's important too. Oil said at oral argument, quote, if the BIA finds this to be a substantive vacature, it's pretty rare that the BIA will nonetheless find that someone hasn't acted diligent in pursuing the vacature, so we think the questions are wrapped up together, end quote. Seems like something important for you to remember too. Like the first paragraph in your related legal brief, important. Where you're filing a motion to reopen after getting a criminal conviction vacated, of course. Which brings us back to Cal Penal Code Section 1473.7A1, vacatures. Remember, the diligence part for equitable tolling is wrapped up in the substance of the immigration effect that such vacatures have, said the government at oral argument. Thanks to Attorney General Barr, only vacatures, clarifications, amendments, and other changes to final criminal convictions that are based on, quote, procedural or substantive defects, end quote, in the conviction will be recognized for immigration purposes. Don't get me wrong, matter of Pickering was already out there, but Attorney General Barr really tightened all of it up. Vacatures or other changes to a conviction for rehabilitative purposes, like say, for example, a judge doesn't believe physical removal equitable in a given case, are meaningless in immigration court now. The power of the agency. When it comes to immigrants, of course. Acknowledging that framework, the Ninth Circuit explained that the BIA, quote, is wrong, end quote, to believe that vacatures under Section 1473.7A1 of California's Penal Code can be obtained solely to alleviate immigration consequences. And oh, by the way, the judge here vacated, stating that it was a, quote, involuntary plea in violation of the Fifth Amendment to the United States Constitution, end quote. As such, quote, the order is clear, end quote, irrespective of what else was said by the parties in their papers, it appears. Vacating because a non-citizen didn't understand the immigration consequences when he pled is very different from vacating because of the presence of adverse immigration consequences, as any immigration lawyer knows. So it seems like criminal conviction vacatures under Cal Penal Code Section 1473.7A1 are totally legit under matter of Thomas and Thompson, although we'll see what the BIA says on remand. No matter what is said during the plea allocation or the papers, says I. Not legal advice. And don't get cute in your papers regardless. That is legal advice. Back to equitable tolling. All that back and forth between the IJ and the BIA was actually quite fortunate for Mr. Bent. It meant that he technically didn't receive a final order of removal until December 22nd, 2021. He got his conviction vacated on May 17th, 2022. So like 6 months later. The motion to reopen deadline, in contrast, is 90 days post-final order of removal. Can we give the guy just 3 little months, having accomplished such an extraordinary feat? Even though, as the BIA reasoned, he technically could have started trying to get his conviction vacated in 2006 when he was convicted? Well, the BIA erred. In the Ninth Circuit, quote, "We measure a petitioner's diligence from the date on which a reasonable person in the petitioner's position is put on notice that something was wrong," end quote. Can't hold that against Mr. Bent when the judge didn't advise him and then he spent over a decade in prison. Quote, "We cannot conclude that Mr. Bent slumbered on his rights, unless he was a psychic. Mr. Bent simply had no basis to know or suspect that he had any rights to pursue," end quote. Only when removal proceedings began does the Ninth Circuit believe that he should be charged with being alerted to something being wrong, meaning that it's 2016 and not 2006 when the diligence inquiry begins here. Still way more than 90 days, though. Let's see what happens. But remember, quote, "Due diligence requires a showing of reasonable diligence, not maximum feasible diligence," end quote. The court discussed how Mr. Bent was pro se fighting his removal case after a decade in prison, and when he really got going, well, he was quite diligent. Heck, Section 1473.7A1 didn't even come into existence until 2017, explained the court. And in any event, might the vacature itself be an extraordinary circumstance that stood in Mr. Bent's way? The Ninth Circuit sent it back for the BIA to consider that, too. Judge Forrest dissented. And it all means congratulations to Carrie E. Hong of the Florence Immigrant and Refugee Rights Project for petitioners, in addition to truly too many people and organizations to name on amicus. But it's everyone in the immigration space. What a case. And that is Bent v. Garland. Our next case is United States v. Manzano, published by the 10th Circuit on August 13th, 2024. This case is about the generic federal definition of murder. It's a sentence enhancement case, and right off the bat, I'm 90% it applies to immigration too. To get this type of sentence enhancement on a federal conviction, the defendant must have a prior conviction that matches the definition of a crime of violence. And the specific guideline definition at issue includes, quote, murder, end quote. So for these purposes, murder equals a crime of violence, which in turn requires an analysis and a definition of the federal definition of murder. And well, I can only imagine that the aggravated felony definition of murder at INA Section 11843A also uses the generic federal definition of murder. So ignore that crime of violence stuff, that's a red herring for this case, and it's distinct from the immigration definition. Immigration doesn't define murder as per se a crime of violence. Focus on just the murder here. So here we go. Of course, the federal crime that got Mr. Manzano into this mess in the first place was felon in possession of a firearm, because it always is. But the crime that made him a felon is also what's at issue for the enhancement. Oklahoma second-degree murder, of all things, in violation of Oklahoma Statute Title 21, Section 701.8. The categorical approach applies to the inquiry, which requires stating exactly what generic federal murder is for sentence enhancement purposes and probably immigration purposes. Didn't take the 10th Circuit much analysis, because a few years ago the 10th stole from the 3rd Circuit to define generic murder as, quote, murder is generically defined as causing the death of another person, either intentionally, during the commission of a dangerous felony, or through conduct evincing reckless and depraved indifference to serious dangers posed to human life, end quote. That's United States v. Marrero in the 3rd Circuit. The inquiry here involves killing in the commission of a felony. Again, quote, the definition of generic murder requires that the underlying felony be dangerous, end quote. Can't just be, I suppose, then the reckless killing of someone during, a felonious drug transaction or something? The Oklahoma courts actually use felonious forgery. So let's go with felonious forgery, not to be controversial. Isn't it the case that if you're committing a forgery and it's felonious, and you recklessly kill someone, you could be convicted of second-degree murder in Oklahoma, because that is killing in commission of a felony? Indeed, that can happen, explained the 10th Circuit. Oklahoma defines second-degree murder as including the reckless killing during the commission of any felony, not just a dangerous felony. Notwithstanding the text of the Oklahoma statute, the government argued that Oklahoma really means dangerous felonies only. Quote then, at bottom, our inquiry is one of scope. What does the phrase any felony in section 701.8 actually mean? End quote. Well, it includes non-dangerous felonies, said the 10th Circuit, looking to Oklahoma appellate case law after, of course, the statutory text. And wouldn't you know it, in 2012, an Oklahoma appellate court held precedentially that, quote, non-perilous felonies like larceny or false pretenses could qualify as predicate felonies for second-degree murder if committed in such a way as to create a potential danger to life, end quote. The Oklahoma Supreme Court itself included felonies that are merely, quote, potentially dangerous to human life, end quote, in the definition, an emphasis by the 10th Circuit. And well, potentially is not necessarily dangerous. Quote, the minimum conduct necessary to constitute Oklahoma second-degree murder, then, is murder perpetrated during the commission of a potentially, not actually, dangerous felony, end quote. Which makes it the end of the story for the categorical approach, even with something as heinous as murder. Second degree, that is. Several other Oklahoma appellate cases apparently also support this position, and the 10th Circuit goes through them. Which must mean that Mr. Manzano is going to get far less time in prison for his felon in possession of a firearm conviction. A decision that is entirely without, unless I miss something, any discussion of the facts of what Mr. Manzano actually did with that murder. That's how the categorical approach works, including in the immigration context. And that is United States v. Manzano. Moving on to Bernardo-De Cruz v. Garland, published by the 7th Circuit on August 15, 2024. This case is about voluntary departure and some other things. Mr. Bernardo-De Cruz is from Mexico and entered the United States without authorization when he was 17 years old. He's been living in Indiana for nearly the last 20 years, where he has worked in a factory and on a family farm. He has 2 U.S. citizen children, daughters, and is a pastor of his church. He's active in his daughters' lives and sends money back to his family in Mexico. He's in removal proceedings because he came to DHS's attention after being pulled over for speeding by Indiana police. An immigration judge denied his application for non-LPR cancellation of removal, likely in part because his U.S. citizen daughters are doing so well, having been brought up well by their father. But also because of changes to immigration law in 1997, non-LPR cancellation of removal is kind of the only thing he's eligible for. The BIA affirmed through a decision issued by a single, temporary, appellate immigration judge. The IJ had granted voluntary departure to Mexico, though, as well, and the BIA reinstated that grant as they're apt to do. But under the regulations, the BIA correctly warned that if Mr. Bernardo-De Cruz challenged that grant of voluntary departure, the grant would transform into a final order of removal. Challenge he did, as is Mr. Bernardo-De Cruz's legal right. There are 3 arguments before the 7th Circuit. All of them were rejected. That regulation that punishes non-citizens who challenge voluntary departure grants at the circuit level is 8 C.F.R. section 1240.26i. Mr. Bernardo-De Cruz argued that regulation, which the Department of Justice just made up, is unlawful. VD is relief after all. Quote, is not easy to achieve, end quote, and avoids certain bars to reentry that attach to an actual removal order. Doesn't help with the unlawful presence bar that'll be triggered when Mr. Bernardo-De Cruz voluntarily departs. But still, leaving with voluntary departure is generally better than a removal order for most people, including Mr. Bernardo-De Cruz, who, if he left, could probably return or apply to return when his eldest daughter turned 21 and petitioned for him. Provided he got a waiver, or that the 10 years had passed, of course. Anyway, Mr. Bernardo-De Cruz lost voluntary departure, now because he petitioned for review to the 7th Circuit. The regulation that took it away is okay, said the 7th, because the statute says that DOJ can, quote, by regulation limit eligibility for voluntary departure for any class or classes of non-citizens, end quote. Plus, actually, that regulation does permit a non-citizen to petition for review and then depart within 30 days and keep their voluntary departure. So they can challenge the BIA's denial and not automatically lose voluntary departure. They just got to leave within 30 days of petitioning for review. Counsel, for whatever reason, and I'm sure it was a smart reason, didn't so much challenge the termination of voluntary departure stuff of the regulation, but attacked that 30-day exception, arguing that it actually kind of creates pseudo-relief that the INA does not provide for, even though that is kind of beneficial to non-citizens. But multiple courts have held that Section 1240.26i's little 30-day thing is okay by applying Chevron deference. But Chevron deference is no more. So to the Seventh Circuit, it's really up to it now to determine if in creating this 30-day grace period thing post-petition for removal for voluntary departure, DOJ went beyond what Congress said they could per statute. They did not. As my quote before implies, Congress gave DOJ broad authority to craft voluntary departure rules. And all of this, termination and the 30-day thing, is within that authority, said the court. Next, there's the well-worn recent argument that the temporary BIA member was unlawfully appointed. This time the argument travels under the Constitution's Appointments Clause. The constitutional provision that I believe Judge Cannon just relied on to find Jack Smith unlawfully appointed. Under the Constitution's Appointments Clause, quote, inferior officers, end quote, can only be appointed by the President, courts of law, or heads of departments. At the time of this temporary BIA member's appointment, the regulations permitted EOIR's director to appoint them, albeit with the approval of a deputy attorney general, and to terms of 6 months or less. But as has occurred in other recent decisions, and even assuming that a temporary BIA member, or temporary appellate judge, whatever you want to call them, is an inferior officer, the Seventh Circuit notes that the reappointment, which I guess is the applicable time here, was done by the Attorney General himself, or in this case, an acting Attorney General. EOIR has been doing that with the reappointments. EOIR has been out in front of this argument for some time, it seems. To this, Mr. Bernardo-De Cruz argued that an Attorney General, quote, has no lawful role in the process, end quote. But that's really just not a good reading of the regulations or the BIA's framework, which after all is supposed to speak for the Attorney General. Said the Seventh Circuit in so many words. I don't know, maybe some circuit will bite. Turning then to the merits of the non-LPR cancellation denial and the adequacy of the hardship to Mr. Bernardo-De Cruz's U.S. citizen daughters, remember that? Well, you can't review much of that anymore, but you can review questions of law at the circuit, and that includes if the IJ or BIA, quote, completely ignored, end quote, evidence. They did not, said the court. Contrary to what Mr. Bernardo-De Cruz argued, the IJ did sufficiently consider what might happen if his daughters had to leave the U.S. with him. Which is to say not at all, because the record showed to the IJ and Seventh Circuit that the children would remain in the United States, so need not consider their going to Mexico. Mr. Bernardo-De Cruz argued that the agency ignored other issues, but well, the Seventh Circuit didn't see it that way, even if the analysis could have been, quote, more thorough, end quote. But more thorough is not the same as completely ignored, making it not a legal error, making it not reviewable. And that is Bernardo-De Cruz v. Garland. Are you struggling to find and hire new talent that you can trust? Does the idea of onboarding, training, and managing virtual staff overwhelm you? Staffy's got your back. Staffy provides top-quality virtual staffing for immigration law firms, complete with HR support to free up your time from the hassles of onboarding, managing, and continuously training your virtual staff. With an entire team of professionals, including psychologists and mindset, task, and performance coaches, Staffy ensures your virtual staff has all the tools needed to help your law firm grow and scale. Visit staffy.cc, that's stafi.cc, and schedule a consultation to claim $500 off your first month of service. Or, of course, click on the link in the show notes. Attention lawyers looking to dive into immigration law. Are you ready to master the art of marriage-based immigration? Introducing the Ultimate Marriage Green Card course, a a comprehensive resource by John Khosravi, founder of the Immigration Lawyer's Toolbox, to kickstart your journey in family-based immigration. His course offers 18 hours of engaging video content and includes monthly office hours for your questions. You'll analyze and learn, through the statutes, regulations, case law, and real-life practice, essential topics like 212 inadmissibility, 245 adjustment, consular processing, and the affidavit of support requirements. The course will also cover practical office procedures, consultations, and sales techniques. Plus, you'll receive helpful samples and templates to streamline your practice. As a limited-time special bonus, the Immigration Lawyer's Toolbox is adding the recordings of an all-day O1 seminar with the best O1 lawyers in Los Angeles. Go to immigrationlawyerstoolbox.com and click on the course link, or email John at info@immigrationlawyerstoolbox.com to sign up. Reference me, Kevin, or the Immigration Review Podcast and get an additional 10% off. Or of course, click on the link in the show notes. For the rest of the episode, we will be in the First Circuit. Our first from the first is Penafiel-Peralta v. Garland, published by the First Circuit on August 12, 2024. This case is about a family of asylum seekers from Ecuador. After Mr. Penafiel-Peralta and his wife had their child, known as GEPC in these proceedings, they knew that they needed a new home. They sold everything that they owned to buy a piece of land from Mr. Penafiel-Peralta's sister Sandra and her husband, but they weren't provided the deed to the property. They thought nothing of it. This was his sister, after all. Several years later, though, and after building a whole home on the property, Sandra told the family they needed to leave. Now, one of the husband's cousins, a former member of Ecuador's army, was interested in buying the land. Not only that, but Sandra refused to return the money paid for the land. The petitioners refused to vacate, and Sandra began spreading pretty bad rumors around town. It got to the point that Mr. Penafiel-Peralta's wife felt like she, quote, was being stalked, end quote. The property was sold to the Ecuadorian army cousin, a man called Barroso. And, deed in hand, he told the petitioners that they needed to leave. The petitioners refused, but were scared about it, particularly given his military history. Barroso said that it could be on good terms or it could be on bad terms, but they were going to have to leave. Worried, they left, and believing they had nowhere else to go, they came to the United States. DHS initiated removal proceedings, and an IJ denied asylum and related relief, and the BIA affirmed. By the time it got to the First Circuit, it had all become about nexus and whether the government of Ecuador was able or willing to protect the family. Not only are mixed motive cases definitely alive and kicking in the First Circuit, but, quote, personal disputes, such as those motivated by revenge, money, or land, must be analyzed under this mixed motive standard, end quote. Rock on. Still gotta be one central reason, though, that is, a viable protected ground, must be one central reason for the harm suffered or feared to get asylum, but that's pretty important to remember. Even if a personal dispute plays a central role, a protected ground could also be a central reason and qualify for asylum. Here there's an argument about an improper mixed motive analysis. Neither the IJ nor the BIA said the words, quote, mixed motive, end quote, at all. Nevertheless, the First Circuit believes that the agency conducted the proper analysis. Both the IJ and BIA analyzed the effect, if any, of family membership in the alleged harm suffered and feared. Okay, but what about the substance? Family can certainly be a protected particular social group after all, and it was argued that that's why this all happened. Sandra and Barroso targeted the family as a unit, the petitioners argued, and the family was recognized in town. Well, the First Circuit has previously held that, quote, the mere fact that a family received threats as a family unit without more does not convert a non-protected criminal motivation into persecution on the basis of family connections, end quote. Family membership must be at the root of the persecution. Not the case here. The First Circuit thinks all this would have happened, family aside, because of the land dispute. That's not to say that the family can't be a central reason to a land dispute when, say, the land is inherited and other factors are present, but here the First Circuit really just sees an unprotected personal land dispute ground. The threat started because of the land dispute, right? Not because they were targeting the family. Nor did anything in the record show that the petitioners would have been targeted by Sandra and Barroso if they had sold the land. Ipso facto, a land dispute. Family membership was incidental or tangential to the court, meaning asylum and withholding was denied. And that is Penafiel-Peralta v. Garland. Next is Lemus-Aguilar v. Garland, published by the First Circuit on August 12, 2024. This case is also about nexus. Ms. Lemus-Aguilar is from El Salvador and applied for asylum and related relief and protection in removal proceedings, but only asylum's at issue here. She claims she and a female neighbor were targeted and extorted by gangs in El Salvador due to her, and I suppose their, membership in the particular social group, quote, single Salvadoran mothers with no familial protection, end quote. She had lots of evidence, including, quote, declarations from various experts, end quote. She saw MS-13 members dealing drugs in her hometown, and a few weeks before she fled, was approached by gang members who told her that she needed to sell drugs for them because she lived close to the field where they were selling drugs and she had seen them. They'd hurt her and her minor daughter if she didn't. Either she sold the drugs, or they'd do harm to the daughter, quote, in front of her, end quote. Deemed credible, the IJ denied, believing it all unfortunate criminal activity and not on account of a protected ground. Nor did the IJ believe that the group was sufficiently particular to be a particular social group anyway. The BIA affirmed. The First Circuit affirmed the agency, on nexus at least. Recall, to qualify for asylum, a protected ground must be one central reason for the harm suffered and feared. That means that the protected ground again must be more than, quote, incidental, tangential, superficial, or subordinate to another reason for the harm, end quote. Here the First Circuit saw criminal gang activity and threatened retribution, and not much more. The motivation of the First Circuit appeared to be, as the IJ had found, quote, because she refused to comply with the gang members' criminal scheme, for her to participate and to assist in their apparent efforts at drug trafficking and drug distribution, end quote. To the court, it wasn't on account of being a single mother without family protection. There was no evidence that the gang knew she lacked family protection, for example. Nor was there evidence that the gang was, quote, motivated by any deficiency in her familial protection when they decided to target her for their drug trafficking activities, end quote. How does one show that when gang members stubbornly refuse to come to the United States to testify and explain their motivations? Just spitballing here, actually, I wonder if there are some former MS-13 members in the United States who would be ever willing to come to immigration court and testify to what their compatriots do in El Salvador. Actually sounds like a pretty interesting piece of evidence. Anyway, the First Circuit notes, Ms. Lemus-Aguilar actually hid at her father's home nearby before coming to the U.S., which, well, undermines an argument that she lacked family support. As to that neighbor who also submitted a declaration, there was no evidence that she was a single mother or lacked family protection. It's equally, if not more plausible, that she too was targeted for criminal reasons, explained the First Circuit. Accepting the expert evidence of, quote, gender-based violence and discrimination, end quote, throughout El Salvador, the First Circuit still wanted more as to the actual motivations of these MS-13 members. Tough case. No finding that single Salvadoran mothers with no family protection is not sufficiently particular, however, or that it isn't otherwise a viable particular social group. And well, if you want support for that group's viability, look no further than Tercios Flores v. Garland out of the Sixth Circuit from episode 158. For next time. And that is Lemus-Aguilar v. Garland. Next is Charles v. Garland, published by the First Circuit on August 15th, 2024. The First Circuit is trying to kill me. This is the sixth case in 2 weeks out of the First Circuit, and it's about sua sponte reopening, the denial of which circuits almost always find that they lack jurisdiction to review. So too here, pretty much. Mr. Charles was brought to the United States as a child, became a lawful permanent resident, but lost that status, likely due to criminal conduct. He's from Haiti, and his primary form of relief is non-LPR cancellation of removal, arguing that his children and U.S. citizen parents would suffer exceptional, extremely unusual hardship if he was removed to Haiti. Seems like he couldn't apply for LPR cancellation, which doesn't have a hardship requirement, because he didn't have enough years in LPR or any lawful status. But that's just me reading the tea leaves. An immigration judge denied non-LPR cancellation of removal and asylum and related relief and protection. The IJ denied cancellation both on hardship and discretion. Yes, Mr. Charles had quite a few arrests at least. Nor did it appear that he financially supported his children. The BIA affirmed. Mr. Charles went on to submit 3 motions to reopen, the latest being at issue here. Not only were most of the charges dropped after the IJ ruled, Mr. Charles argued, but conditions have deteriorated in Haiti, and that's true. Plus, he and his U.S. citizen wife have had another child born in 2021, and that child has, quote, several serious medical conditions, end quote. Mr. Charles even left his job to care for the child. Seems like he's kind of turned his life around, and it seems like a legitimate hardship showing to the child now, today, if proceedings were begun anew, today. But they did not begin today. The BIA refused to grant this 3rd motion to reopen, noting Mr. Charles's, quote, heavy burden, end quote. Plus, the motion was untimely, and the BIA refused to reopen proceedings on its own, using its sua sponte authority. So it's a difficult case, because as the First Circuit explained, circuits can only review such a denial of sua sponte reopening if the BIA, quote, in exercising its discretion somehow violates the law, end quote. Not the case here. Somehow's a pretty broad word though, no? True, the BIA, quote, did not mention the medical challenges presented by Mr. Charles's 3rd child, end quote, which may show that it ignored evidence which I suppose would be in violation of the law. Unclear, at least in the sua sponte reopening context in the First Circuit. But in any event, the court saw the BIA as having considered the evidence, albeit without much reasoning. And that is even though the BIA never actually brought up the medical condition. Still, review was sufficient. It is quite tough to get review of the BIA's refusal to exercise its sua sponte authority. Mr. Charles also argued, as has occurred in the First Circuit of late, that the BIA acted arbitrarily because it has granted other sua sponte reopening motions in the past. 3 unpublished BIA decisions were cited, and I'm sure that Mr. Charles argued that they were similar to his case. But the First Circuit is not aware of any, quote, law establishing that by granting reopening in one case, the BIA limits its discretion to deny relief in all similar, albeit not identical, cases, end quote. Yes, of course, First Circuit, you can establish that law. That's the point. Come on. Plus, explained the court, 3 unpublished decisions is not a, quote, representative sample, end quote. As such, no review possible, meaning petition for review dismissed. And that is Charles v. Garland. We conclude with Rosa v. Garland, published by the First Circuit on August 16th, 2024. Oh, First Circuit. Sweet, sweet First Circuit. If they were trying to kill me with 6, they succeeded with 7. 7 decisions in 2 weeks, with this last one on a Friday afternoon, and 53 pages of Courier New font. What in the 7 hells is going on in Boston right now? And yes, if you must ask, we are binge rewatching Game of Thrones. But hey, at least it's a win for the non-citizen to end the episode on. This case is about adjustment of status and voluntary departure. But really, it's about police reports. Mr. Rosa is from Cape Verde and entered the United States 9 years ago when he was 14 years old. He tried to adjust to LPR status through his mother's petition, but USCIS denied it in 2018. His mother was an LPR and petitioned for him. In June 2019, Mr. Rosa, then 17 or 18 years old I suppose, was accused by a 15-year-old high school student of participating in a sexual assault against her. As the victim tells it, she went home with Mr. Rosa after school, went to his bedroom to watch TV, but was then sexually assaulted by Mr. Rosa and 2 unknown males. One of those males is going to turn out to be Mr. Rosa's brother. Mr. Rosa and one of his brothers, in contrast, told police separately that it was the victim who initiated the conduct on all three boys, and that the conduct that occurred was different than what the victim said. No force involved at all. Seems that Mr. Rosa and his brother were consistent with one another? A bit unclear. But Massachusetts initiated criminal proceedings against Mr. Rosa for attempted rape of a minor. That's not resolved yet. DHS initiated removal proceedings before the criminal case concluded. Mr. Rosa applied for asylum and related relief and voluntary departure in the alternative. An immigration judge granted voluntary departure, finding the positive aspects of the case outweighed the negative aspects. Mr. Rosa appealed the denial of asylum, and neither party appealed voluntary departure. While that appeal remained pending with the BIA, Mr. Rosa's mom became a U.S. citizen, making him eligible to adjust to LPR status. Right, she was an LPR before, and Mr. Rosa was out of status, so he couldn't adjust in the United States, but now she's a U.S. citizen, so his case becomes an immediate relative petition, and the INA Section 245C bars don't apply. So Mr. Rosa moved the BIA for, and the BIA granted, a remand, over DHS's objection. IJ's in a tough spot now, right? The IJ already held that Mr. Rosa warranted discretionary relief, albeit voluntary departure. But now adjustment of status is before the immigration judge, with really only the discretionary determination at play. For reasons unexplained, the matter went to a different immigration judge on remand, and that new IJ did not believe that Mr. Rosa warranted discretionary adjustment of status. All because of the sexual assault arrest and indictment. At the new merits hearing, Mr. Rosa pled the fifth when asked about the criminal stuff, as his criminal case remained pending. The IJ drew a bit of a negative inference from that, as, unlike in criminal court, immigration court allows. Clearly a podcast listener, the IJ distinguished this case from Diaz-Ortiz v. Garland, the en banc gangbuster, literally, from episode 90, where the full First Circuit made quite clear how problematic it was to rely on Boston Police, quote, gang assessment database, end quote, reports in immigration court. Relying on a police report in this case was different, explained the IJ. We'll get to that later. Then the IJ denied voluntary departure, disagreeing with the previous IJ on discretion, which quite frankly was probably a foregone conclusion given that adjustment of status holding. The BIA affirmed it all, including the re-denial of asylum. And Mr. Rosa is currently in Cape Verde, having been removed there when a stay of removal was denied by the First Circuit. But he'll be coming back. At this point, right now, I am 12 pages into this 53-page decision, and I could just keep going on and on and on about what the First Circuit held. But I cannot waste your Monday like that. Here are the high points. First, the IJ sufficiently analyzed the reliability of the police report before relying on it, albeit quickly, and albeit by mistakenly saying criminal complaint when the IJ meant police report in the analysis at least one time. Not only that, the BIA also found the police report reliable on de novo review. IJs need not, under First Circuit law, make an additional fundamental fairness finding before relying upon a police report. Well-researched and heavily litigated arguments, though. But again, the IJ properly conducted the initial required analysis that the police report was reliable. Nor did the IJ mischaracterize the criminal evidence that existed, albeit again, even if sometimes in the analysis, not completely accurate, with the words used. Mr. Rosa's third argument, however, had more legs and resulted in a remand, and that's a big one. It is true that the BIA's 1995 decision, quote, Matter of Thomas, permits the agency to consider non-final criminal charges in making discretionary determinations, end quote. But here, argued Mr. Rosa, the IJ erred by relying exclusively on the pending charge and an uncorroborated police report to deny discretionary relief. It's hard to get adjustment of status review now after Patel, but whether the BIA failed to follow its binding precedent is a legal error that a circuit can review, no matter the underlying form of relief. To summarize matter of Thomas, it allows reliance on police reports, but only through a case-specific analysis that requires giving weight to a police report without conviction, quote, according to the facts and circumstances of each case and the nature and strength of the evidence presented, end quote. None of the cases relied upon by the BIA itself in matter of Thomas involved uncorroborated police reports only, like here. Still, said the First Circuit, matter of Thomas does not forbid sole reliance on a police report to deny discretionary relief. But there's also matter of Aguilar from 1995. That case also doesn't expressly forbid reliance on only a police report to deny discretionary relief, but an uncorroborated one, and only it again, without conviction? Well, after going through lots of its own precedent, the First Circuit held that under Aguilar, an immigration judge, quote, may not give substantial weight to a police report in the absence of a conviction or corroborating evidence of the allegations contained in the report, end quote. And that's what appears to have happened here. No other negative factors were identified at all by the IJ other than the police report and the facts alleged in the indictment, which itself appears to be based solely on the police report, as indictments often are. Such an indictment does not independently corroborate a police report, nor does the, quote, fact of a prosecution itself constitute corroboration, end quote. Importantly, Mr. Rosa denied everything through his counsel after taking the Fifth. So the First Circuit remanded, even though Aguilar was about Section 212C relief and not adjustment of status, by the way. Heck, just listen to the BIA's own words from matter of Aguilar, albeit 30 years ago, quote, just as we will not go behind a record of conviction to determine the guilt or innocence of a non-citizen, so we are hesitant to give substantial weight to an arrest report, absent a conviction or corroborating evidence of the allegations contained therein, end quote. Sounds pretty clear to the First Circuit. The court believes that the Sixth, Seventh, and Fourth Circuit have agreed with this reading, as has the Third and 11th Circuit, just a bit. Seems like the First Circuit is also saying that it would have been improper for the IJ and BIA to consider Mr. Rosa's not testifying as a negative factor in the balancing test. It is proper, however, to consider Mr. Rosa's pleading the Fifth as something that makes it more difficult for him to meet his burden to establish that he warrants relief as a matter of discretion. But it's not a negative factor in and of itself. So, while all of that's pretty important and resulted in the remand, there was also the issue of voluntary departure, or that is, the BIA's finding that Mr. Rosa waived the challenge to the second IJ's denial of it. Well, the First Circuit saw Mr. Rosa's second appeal to the BIA, although less than direct, as sufficient to appeal voluntary departure, too. All of it relies on pretty specific arguments actually made below, so not worth talking about much. But wouldn't you know it, LOL. Here comes 8 C.F.R. section 1240.26i. Remember that regulation we discussed in the 7th Circuit case? Oyl argued that voluntary departure would have been moot anyway, because a petition for review terminates the BIA's voluntary departure grant. After 30 days, of course. But as the First Circuit notes, the BIA never actually granted voluntary departure here, so Oyl's argument misses the mark. What a weird regulation to come up twice in 1 week. But it has been a weird few weeks. All of it means, of course, congratulations Tara Vujukanovic, supervised law student, with whom we have Tiffany J. Liu of the Harvard Law School Crimmigration Clinic, and Carlos E. Estrada of the Estrada Law Office for petitioner. And for the love of God, First Circuit, please, let up next week. I beg you. And that is Rosa v. Garland. So there you have it. You're all caught up with the past week's published immigration cases. I'm Kevin A. Gregg, a partner with the law firm Kurzban, Tetzelli & Pratt, and this has been another episode of Immigration Review. Thank you for listening, and I hope you enjoyed it. If you did, please share it with a friend and rate and review us. Each review helps new listeners find the show. And of course, subscribe to Immigration Review wherever you get your podcasts. If you like what we do and want to become a patron of the show, please check out our Patreon page at www.patreon.com/Immigration Review, or click on the link in the show notes. And if you're interested in an official Immigration Review CLE certificate, email me at kgreg@kktplaw.com with your full name and the episode numbers for the 10 shows you've listened to. Also, feel free to email me with questions, comments, or anything at all, and follow the show on Instagram and Facebook at Immigration Review, or send us a tweet at ImReview, that's IMM Review. I'll be back next Monday for a brand new discussion. Until then, I'm Kevin A. Gregg, bringing you the Immigration Review.